name's Joe Field. I'm an attorney, and I practice in family law. I've been doing so for about 15 years. I practice primarily in Anoka, although I have practiced in the Midway area of St. Paul for a number of years. I'm here today to speak in favor of proposed legislation. I came here today because I practice in this very difficult field. There's a lot of conflict in family law, and boy, if you talk to family law attorneys, a lot of them, they can't hang around that practice too long. And the reason for it is usually because of custody issues. I believe that what we have before you is a bill that will reduce conflict for children in as much as no-fault divorce reduce conflict for spouses. This is key. This is a pivotal bill that children need, but also spouses. And here's what I'm going to do. I get people in my office a lot wanting joint physical custody. And it's amazing to me what goes on, the expressions that I see in their faces when I have to explain to them the existing law. And what I'm going to describe to you is just what I observed with my clients. What I do observe when sometimes I have both of them come in to see me, and I have waivers and all that, but I have them come in, they say, we want to get divorced, and we want to have shared custody, joint physical. So what I observe is that the married couples who come in, that they have accepted or at least acknowledged the inevitability of their divorce occurring in the relationship. And I observe for the most part they have concern. Their face expresses concern about their future. And sometimes they have a relief, their faces show relief that a divorce is coming. But when those couples express to me their desire to share custody equally, I see the following as I explain to them the present law. At first, after I explain to them what the present law states regarding joint physical custody and presumption against it, it's not so much what I see, but what I hear. And what I hear from them is silence. They just stare back at me, neither one speaking, trying to comprehend the significance of me telling them that a judge will generally deny joint physical custody unless the parties go out of their way to lead the judge to determine otherwise. Once the effect of my answer wears off, I hear from them a question, almost universal from those seeking to obtain my services. The question is this: but why? But why is there a presumption against joint physical custody? This doesn't make sense, they tell me. We have raised our kids together, we have a good relationship with our children, we don't want to hurt them by the divorce process. Those are their questions. You see, they view their offer of shared custody as a normal outcome, sometimes even virtuous. But my response to them, and it sometimes elicits a small nervous laugh, is I tell them, and I have no other explanation but this, I tell them, welcome to planet Mars. Because the legislation makes no sense. My understanding is a majority of the other states in the country have some sort of shared or joint physical custody plan in place. You guys probably know that better by your researchers. But I tell them, welcome to planet Mars, and I explain that the law has been justified for years because lawmakers accepted the argument that children should primarily reside with one parent, and because that affords a child consistency and stability. But I also tell them what apparently went unnoticed by lawmakers was that such a shared parenting schedule most closely approximates the relationship that children have with their parents prior to the divorce. The children like that. That such a shared parenting schedule reduces control issues as to parenting schedules typically exercised by the single parent. There's a lot of post-degree fights on, hey, judges would really love it if they didn't have to deal with that and eliminate that joint physical custody. I also tell them that such a schedule allows the children to continue to experience both female and male role models, as opposed to the current formula, which leaves non-custodial fathers as Disneyland dads due to their heartfelt inclination to entertain their seldom-seen children, because the set structures, limits, and disciplines may be taken as unduly harsh to the children. I tell them that lawmakers must have overlooked how the additional freed-up time for the parents may enable them to go to school further, for the parents to be trained in another occupation, or in some cases devote themselves to building a new family. Welcome to planet Mars, I tell them. The present law doesn't make common sense. It's tough to understand. And then they ask me, what can we do then? And I tell them, you can try it. You will most likely be referred by the court to a joint physical custody assessment, and then the court will give significant weight to that assessment's conclusions. The problem, I tell them, is that for the most part, and there are exceptions, that the joint physical custody assessment evaluators speak Martian too. The whole system is greatly influenced by the current law. As this couple gets up to leave my office to think things over, I can see that the hope of a new life free from the stress and contention.
Representative Mahoney, we've been going for 5 minutes already, so, we have
Fine, Mr.
tried to wrap it
Your
up.
committee,
Really quick.
Three sentences.
3 sentences to finish and then we'll be done.
Thank you, Mr. Chair. Well, anyway, free from the stress and contention with moves and spurs of divorce now appears to be beating greater on their faces. Their movements are slow and their faces down. They realize that they must now draw their swords and battle in a winner-take-all custody fight. And the children stand by, not knowing of the likelihood of them being victims of friendly fire. Children suffer in such a fight that could have been avoided but for a change in private law.
Representative Mahoney, could you have your third witness do it in less than a minute, possibly?
Actually, Mr. Chair, let's just move on. What I will tell you is that I had guardian